Hello, hello, hello. This is Attorney Mike Grevin coming to you from Chicago as usual. And wow, we've got a wild one. I have to blame Christina. I'm chatting with her right now. She did it again. She sent me this. It's from Judge McBurney's call down there in Fulton County, Georgia. And we've got a rapper who goes by the name of Little Drill or Baby Drill. That shows you how much I know. I had to Google it to make sure that he was actually a rapper. It returned some results. Apparently the guy's really a rapper. And he's accused of some pretty naughty stuff. I mean, as naughty as it gets. And his attorney's trying to get him out on bond. It's fascinating. And Judge McBurney's interesting. It's a fascinating hearing. Also, and I want to get right into that, but also I want to thank whoever sent this to me. I was down in my office today. I don't know if you'll see this. It's a coffee mug. That's Oscar with me. And the other side, I don't know why. I don't know why it says this. Okay, yeah, I do. And it's awesome. Thank you very much. Thank you, Christina. Thanks. Whoever sent me the mug, tell me. I don't know who it is. I looked, but I couldn't find it. But I do absolutely love it. And I will be having my stream beverages from it this very evening. Let's get going.
All right. Next up is Mr. Wilson, back in 6 North. Or is it 6 South? Mr. Wilson, raise your hand. 6 South. All right. You got a fan base here. All right. Can you hear us?
Yes, sir.
Great. All right. Let me pull up the motion and then we'll get on the record.
Scott, can you hear me also?
Yes, sir, I can.
Andrew's outside waiting also.
What'd you say?
Andrew from Academy of Hope.
Oh, he's got a witness there at the jail that's accessible that might have to come into the booth if the court wants to hear from him.
Okay. We'll see. I'm not seeing the motion for bond, but I bet you'll be able to articulate it. Let's go on the record. Ms. Rivers, are you ready?
Yes, Judge, I'm ready.
All right. Position 4 on our add-on Zoom calendar is State versus Wilson, 22 SC 183525. Mr. Smith represents Mr. Wilson. Mr. Hiles represents the state. Mr. Wilson is charged with a series of gang offenses, murder, felony murder, aggravated assault, and possession of a firearm. All we're doing today, we're doing 2 things.
So that should give you a little flavor of what we're dealing with.
Today, Mr. Wilson. We're talking about arraignment, and then we are talking about bond. Your lawyer has filed a demand for speedy trial, which means we need to move your case along at a fairly healthy clip. I think Mr. Smith will know this better than I because it affects his line of work even more directly, that we don't actually have a speedy trial clock ticking yet, but this certainly would be at the front of the queue because I don't think I have any other cases with the speedy trial demand. And so we're going to treat it pretty close to an active running speedy trial demand, but I just don't think that the clock is technically ticking. Let's start with arraignment. Mr. Smith, is Mr. Wilson waiving arraignment?
He is, Judge.
Has he already waived arraignment, or do you need to fill out one of our forms?
He has already waived.
Great. Then a scheduling order will go out, if it hasn't yet, that will give Mr. Hiles a deadline to get you the discovery he has. And that gives you then a deadline, Mr. Smith, to file any evidentiary motions that we need to work through. And we'll let that flow as it does. So I think then we can talk about bond.
Before we move on to bond, how does the court feel about the state giving me a copy of their witness list as it stands now?
I'm not doing that today. There's other reasons why.
So he didn't ask you. He asked me. And it's not your call. It's my call. But You're asking about witness list as in, hey, if we went to trial next week, what is that witness list looking like?
Well, I'm asking, since we are waiving arraignment, the state has an obligation to provide a copy of the accusation or indictment. In this case, it's an indictment, and a copy of their witness list as it stands now. My understanding is that the state is going to re-indict the case, which goes into my motion for bond and what the court just relayed about being towards the top of the list as it relates to my demand, which will, in effect, make my demand, once they null process this case, ineffective, where the demand will no longer be running. So as a result of that, I am asking for a witness list so I can go ahead and get started and prepare the case. And I think I'm entitled to a witness list as it stands now.
Okay. I understand that a little bit better. A couple things. So fan base, stop waving. No more hearts. He's got it. Okay. Hands to yourself. Thank you. Would you not be able to file a new demand for speedy trial on the subsequent indictment?
I will. And
Okay.
as you had mentioned, that it's told until January. Technically, the state would have Fulton County terms of court of 2 months. I'm just talking out loud, Judge. I know you know this. January, February, March, April, May, June, based upon the nature of the offenses. So technically, they can go towards the end of June, first week of July, and try his case. But it's my intent to refile another demand under 17-7-171, but the state would then have the ability to indict this case anywhere between now and then July, or when the case gets called in for trial. I know that the state was probably going to proffer. We're going to do that as soon as possible. We're going to do that next week, as we hear a lot. And I accept that. They're busy. But at the same time, there's no telling when that will happen. So I've cautioned my client about that. We were aware the state has relayed to me that they plan to re-indict the case. I think there was some effort by the state to beat the 90-day indict or release rule because it was indicted on the 89th day.
Meaning Mr. Wilson's case was?
Yes, sir.
Okay. Got it.
I don't, frankly, understand why they're re-indicting the case. I really don't know. I never dealt with that specifically myself. I should probably get Deborah on here to give her thoughts on it. The defense attorney keeps talking about how they indicted him initially on the case on the 89th day, and the deadline is 90 days. Well, hell, that happens all the time. People file in the EVA statute and civil claims. I mean, all the time. There's really nothing wrong with that per se, but he tries to make that sound like the state's not sure of their case. You'll see. The state feels pretty sure of their case.
I'm going to let Mr. Hiles address that question about witness list and concerns he may have when he responds to your motion for bond. We'll just sort of weave the two together. It's not something you're going to get right now. You're going to need to be prepared to go forward with the bond argument. My limited understanding of the case is that there may well be concerns about identifying who's going to testify, but we'll work through that. And there may be a middle ground where, at a minimum, Mr. Hiles would need to share with you where he is now with law enforcement witnesses, expert witnesses, et cetera. But it could be that lay witnesses, that's a list that is supplemented or augmented later on. But we don't need to work through that 100%, I think, for purposes of bond hearing. But I appreciate you bringing that to the forefront.
Thank you, Judge.
All right. When you're ready.
Thank you, Judge. I am asking the court to make a difficult decision in this case based upon the nature of the offenses to grant Mr. Wilson a bond in the amount of $100,000 in aggregate with some very stringent special conditions. And I'll walk the court through that. I do believe, as a lawyer who's been practicing 22 years, that he is a good candidate for bond. I am at a slight disadvantage as I have not received discovery on the case, but new additional facts have recently come out that I've garnered through prosecution, through speaking to witnesses potentially on the case. And I want to relay what I understand of the facts of the case. The decedent in this matter, the victim, was a passenger in his own SUV. He was driving with a friend who was driving for him. There's some indication that he may have been impaired on intoxicants.
The victim or the driver?
The victim.
Okay.
And I think that's maybe why he had a driver, or some indication he was impaired. We now know that there are 3 individuals that are in the back seat of the SUV. Those three individuals, the state believes that my client is identified as one of those people. The state has relayed at the last time we were in front of the court, not this honorable court, but another courtroom, that the three individuals in the back seat were armed, but so was the victim, and the victim had his gun out at some point.
Yeah, he looks young because he is. He's 20 years old.
In addition, the state has found a gun on the scene that was located outside of the passenger side area, and everybody fled the scene when shots were fired. My understanding from speaking to the state is that there was one gun that was fired, and you have three people in the back seat. The state believes that the forensic evidence would support that my client was potentially the one that fired the gun. It is something we vehemently deny.
Do you deny that your client was in the back seat?
At this stage, yes.
Okay. So you deny any.
Well, I deny that my client was in the back seat at this stage. Or, I mean, that's the best thing you can say. As an attorney, sometimes you're put in positions of saying things like that. And the guy really, it's the appropriate thing to say. Implicit in that is I'm not conceding that yet, but the evidence might show it. But for now, no, Judge.
Connection at all. Yeah. So it really doesn't matter who shot the gun because your client wasn't there.
That's right.
Okay.
Yep. And, admissions in Judico are funny because I don't want to put myself in a posture where I'm ruling out potential defenses. And that's why I said what I said, Judge, if you can read between the lines.
I know, I fully understand. I just wanted to, I was trying to read between the lines as well, because you said we vehemently deny my client fired the gun. I heard that. And so I asked what I asked, but I'm following you.
And you do ask very poignant questions, and I don't know why I'm using Latin. I think it's only when I'm in front of you.
I don't use Latin, but you're welcome to.
Okay. Judge, my understanding is all the people in the backseat fled, including the driver as well fled. There was some indication that the passenger victim had texted the driver to be on the lookout for the people in the back seat, that he felt like that maybe they were going to commit a robbery or something to that effect, is my understanding. At this juncture, the state, as my understanding, does not have a motive for the offense. There is no crossover between my client and one of the defendants that is found or believed to be in the back seat of the vehicle as well. I should note that.
When you say crossover,
meaning that there's no ties between the two of them.
Okay. So you think you know who the
other than they were both in the back of the car at that time. Okay. I'll stop being cynical.
other two? Well,
I do.
First of all, your client wasn't in the back seat, but you think you know, beyond the mystery person who may be named Wilson, you think you know who one of the others is?
I do, to the extent that they have been arrested on these charges and are currently at Rice Street.
Well, that would link them to it.
Yeah.
Okay, got it.
Yeah. And let me walk you through the procedural history of the case, if I can. My client was initially contacted by law enforcement. Law enforcement went out to my client's address. He left his card, notified that he wanted to see him as a person of interest. I was then contacted by Mr. Wilson. Mr. Wilson came to my office. He hired me to reach out to law enforcement. I reached out to the homicide detective. I said who I was. I identified that I was representing Mr. Wilson. In the conversation, he identified my client as a person of interest. We were working through the process with law enforcement when my client was arrested. So
that I follow that, there was this initial, we'll call it cooperation, but before that could amount to a proffer, a sit down or anything, your client was arrested.
Yes.
On a warrant for this, or he was arrested because he ran a red light?
On a warrant for this.
Okay. And was that something you were given advance notice of, or you learned because your client said, hey, I just got arrested for this thing you're helping with?
I was not informed that there was an arrest warrant. My conversations with the lead detective, I think there was at least two, were cordial. We made small talk. We talked about the case. He talked about Mr. Wilson having been a victim in the past on one of his cases, and he's identified or knows Mr. Wilson. He knows that Mr. Wilson is engaged in the music career, and I was not given information that they were going to arrest him. Had I been, I think my client was in a position to turn himself in voluntarily, and that was a discussion Mr. Wilson and I had in my office and on the telephone. In addition,
I mean, none of this is surprising. They're not going to tell you they're going to come out and grab your client. He's wanted for, murder, basically. They're not gonna give a warning shot to the defense attorney. It's just not how it works.
I don't fault law enforcement, though. They have a job to do, and I know the court doesn't either, but at the same time, this is probably like the fifth time that I've tried to reach out to law enforcement, try to be cooperative. I just explained that to Judge Carnesale yesterday, that we even went in and spoke to law enforcement, and then all of a sudden my client had an arrest warrant without being told, even though I've informed them I was willing to voluntarily surrender at Rice Street. The court is aware of the procedural posture of the case, that the case was indicted on the 89th day. The state did so in order to beat the indictment or to beat the 90-day indicted release rule. We now know that the case is going to be re-indicted. I'm going to walk you through.
Beat it. It implies there's something wrong. They're doing it within the time constraints that are before them. They used all of their time, but so what? That's what happened.
Through the Ayala factors for the court. I know that this court is a stickler for details, so I'm trying to give you as much details as possible. Mr. Wilson is also known as Crystal, and his stage name is Baby.
No, he is a good attorney. This defense attorney that's speaking is good. I'm kind of laughing at him a little bit, but it's mostly the position he's put in. He is good. I get the sense that he's not appointed. This is a private attorney that he's being paid for this.
Baby Drill.
Baby Drill?
DRILL. What is drill, Judge? It is what people call rap music, or it's a type of rap music. Some say it was started here in Atlanta. Others say that it was started in Chicago. Big discussion on the listservs where it was started, but it's a nature of rap that is very hot right now and very popular with young kids, and it's called drill rap. He's 20 years old.
It's not popular with middle-aged attorneys, I'll tell you that. Or so I've read.
He lives with his mother and sister. His mother is online. His sister, I believe, is present here in the courtroom. The address is 1761 McClelland Avenue in Atlanta. His sister and mother live with him. His sister is 28 years old. She works for the Hyatt Regency downtown as a manager. He has 3 sisters in total. One sister is a business owner. Second sister, Hyatt, works for the Hyatt downtown, the middle sister. And then his youngest sister works for Delta as a concierge in the first class department. His sister that he'll reside with is 28 years old. She's lived in the house for 4 years. He has no children and he has no passport. As it relates to his family connections to Atlanta, he's a multi-generational resident of Atlanta, meaning that his immediate family and extended family all live in Atlanta. He himself was born at Grady Hospital, being a Grady baby. He attended elementary school at Wilson, middle school at Gene Child Middle School, and then high school at Douglas High School. But then he also attended military school at Milledgeville Academy, and he's completed that. But his graduation degree is from Douglas High School.
So Milledgeville was a temporary, Douglas wasn't working or whatever was going on, back to Douglas and graduated from Douglas.
No, graduated from Douglas, went to Milledgeville post-graduation for a 6-month stint, and then successfully completed Milledgeville as well. He has no psychiatric issues, no medical issues, other than he does suffer from bronchitis and asthma. His mother is a registered nurse. And to tell you a little bit about his mom, she's been a nurse for 25 years. She's been a mother of 4 children. They grew up lower middle class. And her job is, she worked entirely through the pandemic, is to take care of the sick. She worked for a company called Accountable Healthcare. And she currently has a contract with Gainesville that lasts 1 year. So you know that she's staying in the metro Atlanta area and continue to live and reside at that address.
She'll just commute to Gainesville?
She'll commute to Gainesville, which is about an hour drive from here or from the house. As far as his grades go, they were not great, but they were enough to pass or graduate. As it relates to his mother, she does have insurance that includes him under her umbrella insurance. I do want to address with the court just a little bit about him. I know that I have several witnesses that are going to speak to his character, but I think there is going to be one in particular that I'll talk about. Judge, do you see Rondre Walker on the screen?
I'm here.
Oh, you're here, Mr. Walker. How do you want to do this, Judge? Can I call him up to the podium?
If he needs to be under oath, he can come up there. If he's just going to, I don't mean to minimize it because it's important. If he's going to just share how he knows Mr. Wilson, how Mr. Wilson's a good guy, that doesn't need to be under oath. If it's going to become more fact intensive, I want to give Mr. Hiles a chance to ask questions, but that is uncommon in my experience with bond hearings. You'll know better the kinds of things that this gentleman would be talking about.
Yes, no doubt, Judge. So I just want to tell you a little bit about my client's upbringing. I said that his mom was a single mom. After 20 some odd years of marriage, his biological father had left the family, had basically absconded, even though he lived here in Atlanta. And there's a very emotional story that the family tells about when he was a young man, a teenager, he and his girlfriend went to his biological father's house, found out where he lived, and knocked on the door, and they heard shuffling and rumbling going on inside the house. And no one came to the door when he identified who he was. Mr. Wilson went home and he cried like a baby, according to his mom. The reason that I was going to call Mr. Walker, who's also known as Big Dre, is number one, he owns his own business. He's an entrepreneur. It's a very successful business. But he's acted like a father figure to Mr. Wilson, stepped into the role. He told me when I talked to him in preparing for the bond hearing that Mr. Wilson has always been a good role model in their neighborhood. He was a neighbor to him. He's always been supportive of kids, and he's always had a soft heart for people that are homeless. Stories go that he would stop the car, feed homeless, provide money to homeless, and continues to do so up until his arrest. I'm very aware that the state is going to paint a picture of a gang member, of a violent interaction. We're prepared to overcome that to the best of our ability today by describing a little bit about what you see on the social media and why it's there. It's going to be a blurring of both art.
Well, that is the picture we're going to get.
And marketing that the state is going to sink their teeth into, and I do respect their position, though. But I did want to just proffer, if I can, with your permission. Did you want to speak, or can I proffer what you know I talked about? That he actually is a soft-spoken kid. He's polite and respectful. He uses manners. He also has always talked to kids about doing the right thing. And he could speak to that, is what he would be testifying to. And I think his ties to the community are pretty substantial. I'm talking about Mr. Walker and my client, of course. I do want to turn my attention briefly to a witness I do want to call, and that is going to be Mr. Pitts from the CEO of RCA Records and Sony Entertainment. He should be online, Judge.
I'm on. Good morning. Can you hear me?
We hear you, but bear with us 2 seconds. We're going to be able to pull you up.
All right. Mark's iPhone.
Judge, this is Mark Pitts, P-I-T-T-S. Mr. Pitts, do you mind raising your right hand? Do you swear or affirm the testimony you're going to give the court should be the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
Okay. Can you please state your name?
Mark Pitts.
And Mr. Pitts, I know you're on the West Coast, and you got up very early this morning to be here. You're in California, correct?
Correct.
Okay. Can you please identify your name and your job title?
Mark Pitts, and actually the president of RCA. I didn't get the CEO yet, but I'm almost there. The president of RCA under the Sony Music Group.
Okay. And you are familiar with Mr. Wilson?
Yes.
Okay. And I just want to lead you a little bit just to get to the cut to the chase. I know I'm taking up a lot of the court's time. As it relates to Mr. Wilson, he is a current artist that is signed with your entertainment group.
Yeah, that is correct.
Okay. And there's a couple things I just want to relate to the court, and you tell me if I'm correct about this. He is under his employment agreement, he's potentially worth millions of dollars. Would you agree with that?
Yes.
Okay. And the time period for capturing the funds, of capturing that amount of money, is that now?
Oh, absolutely.
Can you explain that to the court?
It's now because he's one of the hottest young prospects in the streets of Atlanta. You know, He was very well sought after, and he has he has great potential to do amazing things. But the time is now. The music industry moves fast. It moves fast, and you definitely have to take advantage of moments.
Would you agree with me that one of the needs for him under his obligation to your company and in order for him to capture his income would be to be in the studio?
Yes, that's definitely, it definitely starts there. We need to record, absolutely.
Okay. And then would your company be supportive of the idea of him being able to reside at home on an ankle monitor solely with a curfew, but not a curfew, but 24 hours, 7 days a week of home confinement, but support him in traveling to and from the studio?
Yes, the company will support him, and I personally will support him.
Okay. And do you have people in place here in Atlanta that will ensure that he does not drive and that he just gets transported to and from the studio?
Yes.
Okay.
I mean, this guy is nice enough, and he makes a decent witness. I can even see the argument. You're saying the allegations haven't been proven yet. Why take away this guy's livelihood? Give him a chance. I don't agree with it, but that's the argument. However, after you hear the prosecutor, it's difficult for me. I mean, I guess this guy says he's with RCA. I don't even know if that's true. That's what he said. That's what he said on the record. He's the president of RCA. They should be absolutely ashamed of themselves. And any company worth their salt would say, we want to cut ties. We don't want to be associated with this. But that's my thought. Tell me what you think.
And then I want to talk briefly about social media. And you and I had spoken recently about this, but his social media, is that entirely run and operated by his record label?
He said every situation is different. But I guess his social media now will be, run by the team.
Okay. And the team is people under your umbrella?
Yes.
Okay. And to the best of your understanding or knowledge, and if you don't know this, it's fine, but they
people with the same exact lack of morals who haven't gotten caught yet
have been operating his social media as of today. Would you agree with that?
I can't say it with great. I believe so, but I can't say. I can't pinpoint exactly when.
Okay. All right. Mr. Pitts, is there anything else that you want to add about the case based upon your understanding of the case?
Yep.
I mean, I just, I know. Listen, I've been in this game for a long time, almost 30 years. I've been around it from. I don't know if y'all familiar with since Biggie Smalls, Notorious Big. I managed him. I've seen it all, and I watch a lot of these lyrics. I don't know. I watch a lot of these. I've been hearing a lot what's been going on with these cases, and these guys, a lot. It's like they like screenwriters. You know what I mean? And I see and I understand. What when they matching the lyrics and what lawyers was trying to do. But at the same time, I watched it for years, and to me a lot of it's personally unfair when I hear when I'm hearing connection to lyrics in cases. I can't speak for everyone, but I've seen enough of it to know that it isn't. They're writing movies.
Things didn't end real well for Mr. Smalls. Is that the example you really wanted to give?
I mean, but
boom! Nobody saw that coming from Judge McBurney. Hey, Biggie Smalls is a really bad example to bring up. I am thoroughly impressed. I was thinking it, but I did not think McBurney had it in him. And he did. And he said it.
Mr. Smalls wasn't talking about lyrics. It wasn't about a lyric thing.
Well, there seemed to be some overlap between lyrics and life for him. So you may want to come up with another example next time you're testifying.
No, I mean, I hear what you're saying, Judge, but yeah. I lived it, and maybe it doesn't rain fresh with you, but I'm just saying I know them. I know him. He was a man that his mother was a Jehovah's Witness, and I knew who he was, and I understand that, but I know who he wasn't, and I knew who he was.
Okay.
Yeah, thanks for nothing. And you exploited that and the violence and the money you could squeeze out of it, and the guy went down. And you're thinking, hey, we've got a new guy who will do that for us. And that's the judge's whole point. But you're not even getting it. Okay.
Nonetheless, Judge, online you'll see that we have a tremendous amount of support from several folks that are within the company that are layered, including people that will operate a social media and have been operating social media. I can proffer that. He has not been operating it himself. Thank you, Mr. Pitts. I appreciate you so much. I know you got a doctor's appointment to go to. Thank you, sir.
Before he goes, though, Mr. Hiles, do you have any questions for Mr. Pitts?
No, sir. I think it was all said.
Okay. All right, Mr. Pitts, I appreciate it. Where are you in Southern California?
I'm in right now. I'm in Century City, California.
All right. Well, thank you for joining us at the early hour.
No, absolutely. You guys have a blessed day.
You too.
Judge, as it relates to my client's criminal record, he has no felony convictions. He's not at risk of committing new felonies. He does have a pending case in Clayton County.
All right, two things. First of all, he doesn't have any felony convictions because he's 20. He was committing felonies, but they're on the juvenile call, so you can't show him as that yet. That's just what the record is showing as far as the way I read it when I'm watching this. Number one. Number two, he has a conviction outstanding in Clayton County, which means I think there's a good possibility that Baby Drill has had a confrontation with Judge Knights. And if somebody can find that for me, please send me the clip.
It occurred prior to it being implicated in this case. I have negotiated a resolution on that case, and I'll read it to you. It's a plea of no contest to reckless driving, where he'll get 12 months of probation. And that comes from Andrea Thomas. I don't know if she appeared in front of you when she was a prosecutor here in Fulton, but she's now in the Clayton County District Attorney's Office. And that email was sent to me, and I could tender that if the court wants to see a copy of it.
What was he arrested for in Clayton County?
Yeah, thank you, Judge. It was fleeing, attempting to elude, tag violation, reckless driving, stopping, failing to yield, improper turn, and a highway violation that I'm unclear what the highway violation is.
But it was all motor vehicles, no gun in the car or anything like that.
All Title 40.
Okay. All right.
But I do have a copy of the plea.
Yeah, vehicle, but fleeing and eluding's bad. Under the vehicle, it's under the vehicle code, but it's bad. That's saying I'm not going to cooperate with anything.
Negotiations if the court wants to see it. And we're just waiting to go in front of Judge Carter. If you were to grant him a bond, one of the special conditions we would ask for is permission to attend court appearances when directed to do so.
Okay.
Judge, I do think that there is, and I'm just going to briefly touch on it, some due process argument. I know what the law says about the state being able to re-indict the case and so forth. But I do think the state has an obligation to bring this case to a correct indictment or an accurate indictment as soon as possible. They understand their obligation because they clearly met it on the 89th day. But I do think that there's something that potentially deep within the Georgia Constitution, maybe Justice Peterson could find it for me.
He will. 80 pages in.
I was expecting that. That's why I'm smiling. So, Judge, I do want to give you my proposal. Oh, I do believe Andre is there. Can you just show him in? Judge, this is a little awkward, but there's a witness that's at the jail that comes and supports the members of the jail. Can he come in and just identify himself?
Is he going to be at 6 South, or do we need to find him?
He's at 6 South. He's standing outside.
Andre's not bad. He just
Hello, sir. How are you?
I'm doing great, and yourself, sir?
Good. Do you mind stating your name for the court?
My name is Andre Norman.
And sir, do you mind teaching us, what do you do at the jail? What do you assist with?
I run a violence interruption program.
Okay. And have you had interaction with Mr. Wilson during his stint at the Fulton County Rice Street Jail?
Yes, I have, sir.
And what has your interaction been with Mr. Wilson?
Mr. Wilson enrolled into our program, and he's been a participant in the violence interruption program here at Fulton County Jail, sir.
And has he been a good participant?
Yes, he has.
Okay. I don't have any further questions.
Mr. Norman, I'm Judge McBurney. Thank you for taking a minute out of your busy day.
No problem, sir.
How many inmates there participate in your program?
Currently, we're working in, I'm a median number. I would say we're roughly around 240 people we're interacting with, sir.
Okay. And how does that, you don't bring all 240 together at once. How is it that you connect with your clients?
The way the jail is set up, there is a zone. There's 6 housing units on the floor. And they're all on one side. There's 6 south and 6 north. There's 6 housing units that we have access to. And we go into the housing units and we speak to the gentleman. We're literally in 6 south right now. So there's zone 100, which has 40 men, zone 200, roughly 40 men, all the way around the 6. So we go into the zones and we speak to the men in the zones.
So it sounds like there are about 240 people in the zone across the 6 zones, if they're 40 each. Does that mean almost everyone is a participant?
Yes, sir. Majority of the people are participating, yes.
Okay. Thank you so much.
Oh, I was so disappointed. Judge McBurney didn't ask the only question I wanted the answer to, which was, is he in the honor dorm? And if you don't know what I'm talking about, you're going to have to go to my Judge McBurney playlist.
Did you have any questions for Mr. Norman, Mr. Hiles?
I don't, Your Honor.
Okay. Anything else for him, Mr. Smith?
No, Judge.
All right. Thank you, sir.
You're welcome.
Judge, I have a proposal for the court. Is now a good time?
So you'll get the last word too. If you want to save it till then, you can share it now. It may help to share it now so that Mr. Hiles can react or respond to the proposal. I know it starts with 100,000.
It starts with 100,000. Thank you, Judge. We would ask for the 10% option if accessible. In addition to that, we would be waiving our speedy trial demand if he were to be granted a bond. And I hate saying that because I don't want the court to feel like I'm saying that to put pressure on the court or the prosecution.
What the hell is he talking about? He doesn't want the court to feel like he's putting pressure. It's your job to try to get bond for your client. You've got an uphill battle and a horrible argument. Not your fault. It's your client's fault. But don't apologize. Buck up, my man.
Monitor being affixed 24/7. We're asking for pretrial supervision, level 3. We're asking for a 24-hour curfew with an exception that he'd be permitted to go to the studio to work, and I can provide that studio name and address.
But that's local. It's not going to Century City to be with Mr. Pitts.
No, that's exactly right. Even though that's something we talked about, but it's nothing that we understand that there's limitations on his travel, and it would be simply for studio work, studio to work, attend his lawyer's office in court. In the court, of course, you would now know is Clayton County and Fulton County. That he cannot drive. He must be driven. No cell phone use, no social media use, no iPad or electronic device to communicate, no contact with either the co-defendants or co-indictees, co-arrestees, cannot control social media himself, no guns or replica guns. As you'll see on some of the videos, or the state presents some of his videos, he does have replica guns in those videos, or people in the videos have those with him. And that would be my recommendation to the court.
And it would be residing with mom, the registered nurse who is going to be doing work in Gainesville, and sister, middle sister, who is the manager at the Hyatt.
And I appreciate you bringing that up because they actually do work 2 different shifts. One works night shift and one works day shift. So somebody will always be home with him that's an adult.
Okay.
And I do obviously have people present here, including his family members.
There were clearly a lot of people here in support of Mr. Wilson. I'm surprised they didn't hold up their cell phones with the lights on as well. All right. Mr. Hiles, what is the state's thought about bond for Mr. Wilson?
Your Honor, sorry. I also want to apologize. I'm sorry for cutting off Mr. Smith and jumping in.
It's all right. Got some energy about this case.
I do. Your Honor, we are adamantly opposed to bond. And I just want to address the reasons I'm not apt to turn over a witness list today. I understand that Mr. Smith is entitled to it, and I'm going to comply with all the court's orders and discovery order. But we have recovered cell phones and jail calls that relay direct threats to witnesses, both in this case as well as others who are believed by this particular gang, PDE, which stands for Paper Drugs Extortion, to be snitching on the gang, directly asking for paperwork. So I'm going through the Crime Victims' Rights Bill.
Okay, so there you have it. I mean, all this other stuff, you can say that the allegations, no matter how serious they are, haven't been proved yet. But he's got evidence that they're tampering with witnesses and intimidating people. He's got good evidence of it. He hasn't turned it over yet, but there you go. That's the whole thing right there.
Specific filings that I am gathering and anticipate bringing before this court within the next week or two, to make sure that those witnesses have all the protections that the law gives them before I turn over information to Mr. Smith. I trust Mr. Smith, but there has been some very public leaks.
Yeah, that's the thing. They all want that cash. You're right, and I think the defense attorney more so than not any of them, and I can't blame him. He's like, can he just get over to the studio, drop another album so my bill gets paid? Because this can be an expensive trial.
After our office has turned over discovery recently, that has given me great pause to be doing that at this juncture.
Right. I don't like you. I don't think the issue is defense counsel so much as then defense counsel, for it to be valuable, needs to share that information. And the weaker links are maybe one step removed from most of the defense attorneys.
And I totally, and that is my position as well. Your Honor, I understand that the defense is adamantly denying that Mr. Wilson was in the car. It's the state's position that he was. This incident occurred just after 2 a.m. On April 8th of this past year, where...
As in 2022?
Yes, Your Honor.
Okay.
And this was a performance at the Diamond Club, which is, I guess, sort of North Buckhead on Northside Drive, for which...
Performance as in, Baby Drill,
no,
a.k.a. Crystal, was performing?
No, Mr. Drill was in attendance.
Okay.
It is two of his record label / gang members performing at that particular incident.
When you say record label, RCA, or is there a local?
So, the PDE does have a separate, in fact, a LLC that is a record label. I'm not saying that they are not part of a record label. I'm just alleging that they are also a criminal street gang by definition and by action. Your Honor, we have detailed video of the co-defendants, Mr. Edgequervis Hall and Sewell Pepper, with Mr. Wilson, Baby Drill, inside the club and then leaving, getting all into the same car. We also have a message sent directly from Mr. Wilson's phone. This was recovered on the phone he was arrested with. It was sent to his co-defendant, Edgequervis Hall, about 2 minutes prior to Mr. Hall leaving the club with the victim, that said, "I am outside with all the guns." That is what was sent from Wilson to co-defendant Hall, who are close associates and members of the PDE gang.
So Mr. Smith shared with me that he, of course, is climbing the steep learning curve of discovery. Maybe doesn't have all these things. Are the things you share with me right now, the text, et cetera, something that Mr. Smith already has, or something that he will get soon because he's filed the waiver of arraignment?
He will get very soon because he's filed the waiver of arraignment. We're going through making.
That is a great question from the judge. What he's saying is what you're telling me is absolutely compelling, but I'm getting your side of it, state. Not that I don't believe you or anything, but does the defense attorney have it in his possession, and can I get the adverse point of view? Can I get their argument on it yet? The answer is no, not yet. I will get it to him soon. That is the answer. But that is precisely the nub of the issue at the moment.
Sure that the witnesses are turned over in the proper way. It's not a hide the ball issue. I'm going to walk him through discovery.
No, and that's not my concern at all. My experience with you, it came up yesterday. You'll say the cell phone has 1,000 pictures. Here are the only 2 we care about. You can look at the other 998, but this is what the state's focused on. Mike, I didn't ask the question well. You're sharing with me some of what you think will come out as this case develops. It's just something that Mr. Smith, if he's heard about it, he would have heard about it by talking with his client, not because you provided it already.
That's correct.
Okay.
I have not provided.
That's not a critique. I just wanted to, if Mr. Smith says, gosh, I didn't know that, there isn't a way he would know that.
I don't think
at least
he would
from
know
the state.
that. I don't think he would know that information. And he will be getting a copy of that cell phone dump along with the.
This is huge because I do hearings all the time. If that has not been provided to the defense not saying anything about it is basically acquiescence. And he's saying this is all locked and loaded. There is no good argument against it, or I'd hear it because he's got defense counsel. His defense counsel is competent, and if he can't come up with an argument against it, then this does not look good for him. So it already doesn't look good for him, but it's toned down a little bit because he's saying, look, the defense hasn't had a chance, and you'll see that play out through the rest of the hearing.
Many other things.
Okay.
Your Honor, this was an execution style shooting. The victim was shot just behind the ear over the back seat. It's the state's position based on video evidence that Mr. Wilson was in the seat directly behind him, and that forensics would show that he, in fact, was the shooter. He is seen fleeing the car. That is on video from where it parked in Midtown.
Okay, so the state's alleging execution style shooting from the back seat passenger of a front seat passenger. Nasty stuff.
And so I also want to point out that he does have a juvenile record. He has a adjudication of delinquency for a robbery under 18 DL 03008. That adjudication of delinquency was on May 13th of 2019. I'm sorry, it was on October 10th, 2018, and the case was actually closed and transferred to a different county on May 13th of 2019. I don't know where it was transferred because there is an adjudication of delinquency, whatever county the juvenile resides in is going to be the county that handles it. And once it leaves Fulton, I don't have any more information on it.
Okay.
And then I just learned today that there was a negotiated resolution on the
Clayton case?
Yeah, the Clayton case. So I do know, though.
So everyone is learning things on both sides.
That is true.
All right.
That is true. However, I do know that prior to Mr. Wilson's arrest on this case, that Clayton case was in bench warrant status. And I believe has been since 2020. You can.
Okay, that's really bad too. We're at a bond hearing, and bond is being set to ensure that somebody shows up, and also safety of the public is an issue. I'm not a criminal defense attorney or a prosecutor anymore, although I was eons ago. Never dealt with a hearing like this. But that is straight to the heart of the matter. He's got an open warrant in Clayton County, which I believe is a neighboring county. But yes, it's a smaller charge, but it shows he's not going to show up. If he's not going to show up on a small charge, what's he going to do if you give him bond on this?
Correct me if I'm wrong.
Well, he's going to get a chance. He's not going to interrupt you. He's making notes, and I'm making a list.
So, Your Honor, there was a video call between this Mr. Wilson and three other identified gang leaders of PDE. On that video call, it was observed that Mr. Wilson and the other members on the other line in this three-way call discussed getting the defendant a cell phone inside the jail. Just 2 weeks ago, I believe on August 16th, after having time to review that call, the cell was shaken down and two phones, one attributed to
That's a good question. What would I do? First of all, I'm not a criminal defense attorney, so my opinion on this is not, doesn't carry much weight. But I will say I think the defense attorney is doing a good job. I'm sitting here sort of having fun with some of his arguments, but that's because the factual situation that he's put in, not because he's a bad attorney.
Mr. Wilson were recovered from his jail cell at Rice Street.
Okay, so full disclosure, Mr. Smith, this is, I felt like I had heard Mr. Wilson's name before. I signed a warrant authorizing the exploitation of the phones. That this is why what you were saying started like, wait a minute, some kind of call, and then a cell was tossed. So I'm aware, and I just didn't know which case that went to. So I'm aware of that situation. I think an iPhone and some kind of blue tech phone were found in the cell that Mr. Wilson was in. He may have had a cellmate, but there were 2 phones found there, and your office is seeking to find out what's on them.
And out of an abundance of caution, we went ahead and got warrants, although I do not think a warrant was necessary, as I don't believe there's any expectation of privacy in the jail, but we decided best practice, we'll get the warrants. So additionally, Your Honor, on June 9th of 2022, Mr. Wilson made a phone call to an unidentified male. On that jail phone call, he specifically listed 2 other known and identified gang members inside PDE, and he said to that individual that he believed that those people were snitching, and he specifically in there asked for the paperwork. It is my understanding, having done this for years now, that paperwork refers to police work or any sort of government documentation of an individual who is listed as a witness or said to be speaking out against a particular person or organization, because these types of organizations, they do require some sort of proof before they take internal action against others. So that is what I believe that to be. There was also another conversation between jail call between known gang members, for which another individual, I'm not going to name him, who is a known member of his gang, they refer to him specifically as being held on the 5th floor at Rice Street, and said that he was being harassed by other gang members, and because of that harassment, quit claiming the gang, quit claiming PDE. That discussion was then that it was over for him, and Mr. Wilson's direct response was, I'll no longer save him. Now, my understanding of that is that he is no longer receiving the protection of the gang, and is also subject to potential violence for his no longer claiming membership of PDE, who also refers to themselves as 4L, or for life, 4L gang. Again, Your Honor, I do want to touch on drill music. That is,
I mean, yeah, that's prosecutor saying it nicely in court because you have to there. But yes, then I can no longer protect him. Has all the implications that you would suspect. I'm sure.
It is a form of rap, kind of an extension of trap music. It is very violent. There is a debate between Chicago rappers and Atlanta rappers as to where it has started. And that debate of where drill music has started has actually spilled into violence in the streets of Atlanta when many of these Chicago rappers have come to Atlanta to record. Mr. Wilson's Instagram itself, he posts many things. I know that it was said today that going forward, his Instagram account will be run by the record label, but in the past, based on...
Oh, wait. Do we have a Chicago-Atlanta feud going on about drill rap or whatever the hell they're calling this? All this always cracks me up because it's just dopey. Like, everyone's like, well, you copied me and you copied me. And the fact of the matter is, in terms of artistic endeavors, yes, everybody copies everybody. That's how it works. You're all influencing each other. So everyone's right in a sense, but it's just so mature. Put the guns away. You have to kill each other over it. Just make a better album.
Direct messages and such, it is apparent that Mr. Wilson himself was running it. He posts pictures with guns and claiming that
probably.
this gang is 4L. Anyone gone against it is going to die in this shit. I'll leave out some of the other language. So, Your Honor, as it is right now, the state feels that, one, there is a strong case against the defendant, which the defense needs time to go through the actual evidence. But that combined strong case, placing him in the car behind the victim as he was shot, is a strong incentive to flee. Additionally, as a gang member and based off of the messages obtained from both the cell phone he was arrested with and video calls and jail calls from jail, is a threat to intimidate witnesses. He already has some sort of influence over powerful people just to get a phone into the jail. If he were out on the streets, that influence would be that much stronger. I'm sure RCA wants him out if he's worth millions, but I can give you millions of reasons they want him out, and what their reasons for having him out are strictly monetary and for their own gain. They don't care about Mr. Wilson. They care about their own gain. So I don't think that goes to any sort of Ayala factor.
More to the point, they don't care about the victims or the potential victims of Mr. Wilson. Let's be honest.
Or reason to let him out. And in fact, you picked up on it as quick as I did. I would have said it that, rap music translates to violence, and Biggie Smalls was a terrible example of.
So I didn't say rap music translates to violence. There's nothing that I said. Peculiar example that he selected as someone whose life and lyrics seem to collide in a fatal way. That was my point.
That is
May I say something?
It's in general. It is not rap in general, but violent lyrics can translate into violent endings. Point in case. And I think that is apparent in this case as well. Your Honor, I think I'm asking to deny bond as a threat to reoffend. He has committed felony offenses, whether he was a juvenile or a adult. A threat to flee based on the bench warrant status, as well as a strong case against him, and an absolute threat to witnesses and the community at large, based off what has been recovered. And for those reasons, Your Honor, we ask that you deny bond. Briefly, I spoke with the family last night.
Give me the last name of the deceased so I can be referring to him beyond just the deceased.
Yes, I was going to Scott.
Mr. Scott.
And
okay.
I believe, so there was some confusion as to whether the bond hearing would have been today, with communicating that from my office to the family.
Okay.
So they weren't planning on being present for the plea and arraignment, but I did speak with the father last night.
Well, let me just ask, there was someone named Rondre who was making noise. I moved Rondre into the waiting room. If Rondre is with Mr. Scott, I'll pull him out. Is there anyone else on the call who can hear me who is here on behalf of Mr. Scott or his family? Okay.
Okay. I wanted to make sure they were going to try to be here if they could. But they just wanted me to relay that they are adamantly opposed to bond. They feel that this was a senseless killing, and it was a miscommunication of scheduling between my office and them as to why they're not here. It has nothing to do with them not being supportive of their son's case as it tracks through the system.
What can you share with me with some level of confidence, as opposed to speculation, as to if and when the case would be reindicted?
So I have learned that if it's not reindicted Friday,
as in day after tomorrow.
I'm still structuring it. It will be September 12th, because that's going to be the next day that this new grand jury coming in will actually be available.
Okay. So it's either the 2nd or the 12th.
That's correct.
Any reason it wouldn't be the 12th that you control?
If it is, it would be it would be a shock to me, nothing that I control.
Would it be something you could relay to Mr. Smith, because he will be tracking, understandably, where this is going next?
If there is some sort of delay, I will tell him the reason why. And
I mean, the reason why may be something you can't share, but you can keep Mr. Smith apprised.
I will.
Because I'm going to assume that come the 2nd, or at the latest the 12th, there'll be a re-indictment. It'll get assigned somewhere else initially. It'll very quickly get bounced to me. And then we can pick up where we left off in terms of, at a minimum, getting discovery to Mr. Smith, and he's moving forward with motions and whatnot.
Understood. Yeah,
Okay.
I'll share the updates with the court, Mr. Smith. I'm not, we're not going to hide the ball.
Okay. And that wasn't the point. I just wanted to make sure that we would know promptly when something changes.
So,
Okay. All right.
Excuse me.
Yes, Mr. Wilson, why don't you wait for Mr. Smith to come back to the podium, and then if there's something that you wanted to add, maybe you can. Mr. Smith may not want you to add a whole lot, but it is certainly Mr. Smith's turn to say anything he wants in response. I got a couple questions for him, and we'll wrap it up.
Thank you, Judge. Judge, I don't want to proceed on a demand in this case. But at the same time, as we heard earlier today, 1,000 days in custody on a co-defendant case. And I know it was transferred from Judge Newkirk, who's no longer handling criminal. He might be retired. I don't know that.
No, he's still here. He's in the family division, but that actually wasn't a Newkirk case. That was Downs and then Reeder but the issue is one that could recur here if the co-defendant gets not the public defender, gets the conflict defender or beyond. We have had no luck. And so it is a very real concern. And it is a reason for a defendant, whether it's retained or appointed counsel, would say, you're going to have to decouple me from this situation because the system is failing us and we aren't getting those conflict attorneys, whether it's Metro Conflict or C3 and beyond. And that's an issue.
I appreciate the court saying that. My oldest client awaiting trial in a murder case is 4 years right now here in Fulton. It's the longest I've ever had a client wait. Is it a co-defendant situation or it's a judge issue? It's a co-defendant situation. Okay. When I draft the demand, the 171 demand, it unnerves me because I don't want to do it. You're going blind. You could call me in, I think, may say 10 days or 7 days. That won't happen here, but you're right. It accelerates things in a way that's not always advantageous to your client. Yeah, and they also say, right, in the constitutional speedy trial case law, it's always advantageous to the defendant to wait, and I believe that. Memories fade and cases potentially get better and usually do. But at the same time, I don't want him to sit and linger where it's a defensible case. As you heard, one gun was fired. Yep. I proffer that. The state didn't. And then multiple people in the backseat are identified as the state as having guns on video. I did know about the text message Kara Convery before she left that told me that my client apparently could not bring guns into the.
Yeah. The problem is, I don't know, and this is speculation, but from what I'm gathering just from this hearing, yes, but they have the bullet and they know which gun it came from. It's not going to match all three guns, and that matches your client. So I mean, I get it, but it's just a weak sus argument.
Venue that you were being wanded down, and my client has been identified as potentially sending a text saying, "I'll hold the guns for you." I don't know how you can spin that. I think you can spin it both ways. One of the special conditions I am going to be asking the court to issue is a Fourth Amendment waiver going forward on his home. He's under pretrial release supervision 3 if the court believes what I'm asking for the court to do. I was also aware of a juvenile record. I didn't bring it up because I did not know that juvenile records were considered by the court as relevant, but if they are.
It depends how old the defendant is.
Yeah.
It is chronologically relevant if someone is 20 years old and it happened 2-3 years ago. If your client were 50,
Yeah.
why bring that up? But it's a data point, but I appreciate that it is processed in a very different way. I only have one question about it. Mr. Hiles mentioned that there was a county change, and you had made it sound like Mr. Wilson had a...
It's a data point. He's talking about his juvenile record. It's a data point. He's 20. That's all he's got potentially available to him was a juvenile record. And he's got one, and a bad one.
fairly stable address.
Yeah.
And so do you have any insight as to why the supervision or whatever it would be called would have shifted out of Fulton County? And if so, where would it have gone?
I don't think it was shifted out of Fulton County. I think it was shifted to Fulton County, if I'm not mistaken.
It was a juvenile case that was not in Fulton and then came here?
I don't have that information.
Okay.
I mean, that's under seal. I'd have to unseal it.
Okay. It's not a huge deal. I just was curious.
But I know, yeah, I'm sorry. I don't mean to interrupt.
Go ahead.
But I do know, Judge, that in that case, it was a stolen car in which the victim had come to court in support of my client at some point, is my understanding.
Okay. What about the
Probably because he threatened him.
supposed bench warrant in Clayton County?
So I was looking it up as we were sitting here. It does appear that there was a motion to set aside or set aside potentially on their equivalent of our Odyssey system. But I filed an entry of appearance as soon as I was hired by Mr. Wilson and was able to arrange that deal. So the bench warrant will be recalled in stanter once he answers the plea.
Or why would he have a bench warrant? He's someone who shows up all the time.
That's a great question. And the answer is, I don't know that he has a bench warrant, number one. Number two, I do see what appears to be a set aside on the filings, but I don't know that he has a bench warrant on the traffic violations.
Okay.
So I don't, without certified copies or without having seen the record, but Ms. Thomas didn't raise it when I addressed it with her and via email. And she obviously made me a recommendation that, especially for a tough prosecutor, supports the idea that the case was not as serious as the 7 allegations in the accusation.
There are lots of reasons why it could have been resolved that way. Social media. It sounds like today, Mr. Wilson doesn't manage his social media, which is good to hear since it would mean he has devices he shouldn't have if he is. And it sounded like Mr. Pitts was saying, nah, there's a team that does that for him.
Yeah.
Do you have any insight as to when things transition to RCA managing the social media of Mr. Wilson versus he's got his own? There are references to Instagram, and I might be shocked, but I don't move in some of those circles if Mr. Wilson didn't have his own. This is the real baby drill, and then there's RCAs where things are photoshopped in.
Oh, stop it, Judge. You dropped the Biggie Smalls reference earlier. Just keep going.
And everyone's in soft focus and they're making their money selling their albums. Are you saying that for some time, and if so, how much time is it that Mr. Wilson actually has had zero control over what his social media presence is?
Approximately 4 months. And the person that has been in control of it is online with us as well.
Okay. And that would be it. I'm going to date myself. That's Instagram, that's Facebook, that's whatever people use, TikTok, all those things would be not Mr. Wilson. He doesn't have a way. If he got a new set of kicks he wants to show the world, he can't unless his handlers say, we want to show you with those new Jordans.
Correct.
Okay. But he's been in custody for how long?
For approximately 4 months.
Oh, okay. So there's almost one-to-one overlap.
A little stereotypical there, Judge. I mean, accurate, but a little stereotypical.
Up until he was arrested while you were interacting with the police trying to sort things out, he managed his social media. But after he went into custody, then it's been managed by RCA handlers.
Correct.
Oh, okay. Well, that makes much more sense. Okay.
And that's going to continue going forward. And he's not going to sign up for any new social media accounts. And he doesn't have any personal other than what
has been taken over by RCA. Okay. But a semi-bright line one could draw is social media pre-arrest on this case. That's Mr. Wilson. Social media post-arrest, that's RCA.
Well, I can only tell you that I know that RCA took it over approximately 4 months ago.
Okay.
As far
I
as
don't know about the time he was arrested. It's not 8 months ago or 2 years ago, so that if Mr. Hiles says, look at this Instagram post and he's got 2 AKs and one of them is actually firing bullets, and that's 10 months ago. I'm making this all up. That's not RCA as far as you understand.
That's not RCA. And there is, I've looked at the social media. I don't see anybody firing any guns.
I didn't say there was, but just if one of the things Mr. Hiles was relying on was social media presence. He didn't go into a lot of detail. You don't have it yet, so it's appropriate. He didn't go too deep. But if he's referring to things that Mr. Wilson is allegedly saying or doing or posting, and it predates his arrest in this case, it is more likely social media activity that Mr. Wilson engaged in rather than someone at RCA saying this might sell some more albums if we had a picture of you holding a replica firearm.
Oh, thank you for bringing that up. I think that the whole purpose behind the social media postings in the last year has been geared towards selling songs.
Okay.
That was
Understood.
a roundabout way to.
Yeah, I mean, him posing with guns and acting violent has nothing to do with him, you know, and allegedly shooting somebody with a gun here. Oh, nice try. I get it. He's working with the facts he has.
To answer your question, but also put in my little feelings about rap music and how potentially it can be misconstrued, art versus crimes and so forth.
Right.
I just had this conversation
This seems to be life imitating art here.
2 weeks ago with Congressman Johnson, Hank Johnson, in person, and he's petitioned or he's presented proposed legislation where government should not be able to use art to be able to establish crimes.
It is front and center in our culture right now. Just down the end of the hallway with Judge Glanville. That's where the big one is.
What's this Judge Glanville case? Some of you law nerds tell me about this Judge Glanville case down the hall that I need to be doing a video about.
Yeah, for sure.
Okay, I appreciate that.
Yeah.
All right.
And I'm available for any other questions that the court might have. I know my client wanted to say something, but I might have addressed what he had to say. As far as the cell phones that were found in his cell, I don't think there was anything inculpatory on what they're claiming that they found. Otherwise, they would have brought it up.
Beyond there being cell phones in his cell.
Beyond there being 2 cell phones amongst 2 roommates. That's
Okay.
correct.
All right. Mr. Wilson, I want to make sure if there was something you wanted to add that was not you talking about your case, because that's what you need to not do right now. Was there something that you wanted to add that Mr. Smith didn't? Or do you feel like he's covered it for you? He looks frozen right now.
Interesting.
Mr. Wilson, your screen froze up for a minute. Were you able to hear what I just asked?
Yeah, I heard you, sir.
Okay, you feel like Mr. Smith has covered it for you?
Yes, I was saying they didn't find 2 cell phones in my cell. They found 2 cell phones inside the dorm.
Inside of what?
The
The
door.
dorm.
The dorm. Okay.
It was one cell phone in the cell, and there was another
Wait, was it the honor dorm? That's what I need to know.
cell phone in another cell. It wasn't both inside one cell.
Okay. Point well taken. Appreciate you clarifying that. All right. At this point, Mr. Wilson, I'm not going to set a bond, but what I do want to have happen is Mr.
There you have it. There you have it. So, I mean, nice as he is, Judge McBurney was following along.
Hiles to get to Mr. Smith the discovery as promptly as he can, independent of whether there's going to be a superseding indictment, because I want Mr.
Seriously, I'm going to have to do a playlist. I never intended this, but this is the 3rd rapper one. I had a rapper Sav sit, and I had Machine Gun Kelly on just being like dopey at a traffic stop. I didn't know who he was. I did the whole video. I still didn't know who he was. And then later somebody mentioned him, like, oh my God, I did a video about that guy.
Smith a chance to go through the discovery, in particular, jail calls, et cetera, so that if we should revisit this, we'll do it sooner rather than later. I have several concerns. The primary one is the risk of improperly influencing witnesses. Second, so I'm going to finish talking, and then if you've got any questions, Mr. Wilson, you can ask your questions. But my primary concern is I think about the Ayala factors, none of which is strength of case, but one of which is the ability of potential witnesses to go about their business, uninfluenced and unharassed by folks associated with anyone on the defense side. I'm concerned about that. But much of my concern arises from the way the state has processed, interpreted phone calls, video calls, et cetera. I want Mr. Smith to have a chance to review those himself.
Jerry, I can't remember the name of the Machine Gun Kelly video. He was just being a jagoff at a traffic stop. It wasn't too over the top. And then I did have a full-on soft-set rapper who was trying to not pay taxes.
Because he may say, Judge, we should reconvene. You ought to actually listen to these, or there's a different way to interpret these such that we don't need to worry, or I don't need to worry about Mr. Wilson either directly or, far more likely, indirectly seeking to influence witnesses who are associated with this case, know something about this case. It is a risk that arises in cases like this, where there is an allegation of an association of people. Some might call it a gang, some might call it a music label, some might say
I'm going to call it a gang.
They overlap. They seem to overlap in this case.
I'm in the gang camp.
But it is an all too frequent problem that someone is initially willing to talk to law enforcement about what happened, and then there's a phone call or a text or an Instagram post, and all of a sudden that person stops talking, can't be found, has moved to Chicago or who knows what. And I want to avoid that happening in this case. And I have...
Wait, how does Chicago keep getting sucked into this deal? This is a Fulton County case. We got nothing. On behalf of the city of Chicago, we've got nothing to do with this. We've got our own problems. Okay?
Sufficient reason at this point to believe that has already begun to happen, that I'm going to deny bond. I'm less concerned about the prominent Ayala factor, risk of flight. Mr. Wilson benefits from very, very strong family support. This is one of the more stable family situations that I get to hear about, and we ought to celebrate that. I do believe that Mr. Wilson's mother and sister would do their best to keep track of Mr. Wilson, but there's only so much they can do. I appreciate that Mr. Smith said no cell phone, things like that, but in this day and age, it is impossible to build a cocoon around someone that would keep them from communicating with others if they are bound and determined to do that. And my concern is that those communications would result in improper interference with the state's movement forward with its case and working with its witnesses.
Boy, that was a nice way of saying I don't trust you for 1 second to not do nasty things to the witnesses against you.
Appreciate RCA's interest in having their asset back and working. That weighs with me in no manner whatsoever. Mr. Wilson could have been flipping burgers at Burger King, and they would want him back as well because he's a good burger flipper. That's just not something that I weigh here. RCA is going to need to find someone else in their stable to make them millions. But for right now, that's not going to be Mr. Wilson. Mr. Smith, most of
There you go. That'll make a lot of you happy. Judge McBurney, and he's correct. He's saying, I don't care if he makes money or not. That's beside the point.
First of all, I invite you to revisit this. And I mean that. You are not being overly aggressive on behalf of your client if after you have digested some of this discovery, you say, we need to talk again, because here are 3 more reasons why you need to not worry, Judge, about Mr. Wilson and his associates influencing witnesses in this case. That's my primary concern. And so as you're thinking about ways to address that after you process the discovery, we should reconvene. But right now, I don't see a way. I mean, frankly, Mr. Wilson being where he is doesn't prevent him from communicating with others. Witness the cell phones. But I believe that if he were out, even under the substantive and meaningful restrictions that you've identified, we would be amplifying Mr. Wilson's ability to do that, despite the folks who are present in his life, the substitute father figure, the actual mother, the sisters, etc. Those are folks who care about Mr. Wilson and were present in his life when he wound up in this scenario to begin with, much to their chagrin. So I'm going to maintain the status quo. The other thing that I would consider that would be a changed circumstance beyond addressing this concern about influencing witnesses would be if we run into a pattern of delay that is occasioned by we now have multiple defendants and we cannot get a lawyer for that third defendant. We'll get a lawyer for the second defendant because the public defender should be able to take one if they can't hire their own. But if we get stuck in a situation where there's a third defendant whose case has stalled and the state is not interested in severing, then we will need to start talking about bond again for those who are waiting to move forward.
Ouch. That's putting pressure on the state to sever right there. He's saying, well, if I can get an attorney to represent him on the third case, then I'm going to run into a bunch of trouble and I'm going to let these guys have bond. Which I understand it because he's also weighing the constitutional things. This is the stuff judges are dealing with. But I mean, that to me was a clear shot across the bow.
Solely because our criminal justice system can't provide constitutionally entitled representation to the third or fourth or fifth defendant. Mr. Smith, any questions about what I just said, Mr. Wilson's situation, so that you know how best to move forward?
No, but I do have a question about the scheduling order.
Yes.
So demand.
Has it already gone out, or
no? When do you suspect it will go out? And how do you want me to handle the list of witnesses? Clearly, there's a state witness that is unknown at this point. That is the driver of the vehicle. I want to get his information. He's not listed as a victim in the case, but I want to get his information and I want to interview him.
okay?
How can the court assist me in acquiring that information?
So, couple things. The scheduling order, your first question, will go out soon. It may be that Ms. Nelson was just waiting for today to happen because it was also arraignment, but as usual, you're ahead and have already filed the waiver. The scheduling order will give Mr. Hiles a deadline to get you discovery. Then there is a later deadline for you to file evidentiary motions. Then there are only 2 days after that. It would be the hearing if there's a motion to suppress or something. There's a status conference, last day for a plea where your client could withdraw his plea if he didn't like his sentence. And there's a trial date. So we try to move things quickly. They'll move faster as long as the demand remains in place, even though that clock's not ticking. So we don't get caught short when the clocks can start ticking and all of a sudden everyone files them. So that's the scheduling order question. What I'd ask you to do is first get the discovery, look through it, and then if there is that witness you mentioned, and there are others, we ought to have probably just a teleconference, so you don't even need to come on into court. I don't think your client needs to be involved. If you want him to be, then we'll come to court, but I think it will be a more productive discussion because it's procedural. If it's Mr. Hiles and you and me, Mr. Hiles will be in a better position to speak freely about these are my concerns, and I'll be in a position to say, okay, there still has to be disclosure. How can we do that in a way that accommodates Mr. Smith's right of access? So we'll address that. Get the discovery first, get your arms around that, and then just reach out to Ms. Nelson saying we need to have a teleconference with the judge to talk about witness issues. And that can happen whenever. I always have time before court or after court, so 8:30 to 9 or at the end of the day to manage something like that.
And then the last thing, Judge, I'm not giving up on bond. I'm going to get a copy of the transcript, see what the state had alluded to. I tried to take copious notes, but it's not going to be as good as the transcript. So if I get the court reporter's information, I'll order the transcript now, and then I'll compare that once I acquire the videos and audio recordings that they're claiming that my client was harassing or intimidating witnesses. And then I will potentially come back to the court as the court directing me.
That's my invitation. It's not direction, but it's an invitation. That's exactly what you should do because I may be overemphasizing this, and some of this is experientially driven. But in cases where we've got allegations like this, you know this just as well as I do, witnesses start disappearing, and then in the end we learn, well, that's because defendant X, not directly, but through colleagues, made it so that witness was very, very disinterested in being involved anymore. And I want to try to limit that. All right. He's already waived arraignment. It just may not have hit the docket yet. You e-filed it.
We e-filed it.
Okay. It is being reindicted on the 2nd or the 12th, and they'll be adding some defendants. All right. All right. Thank you.
May I have an excuse?
Yes. And family, thank you for being here. I appreciate it very much.
This is kind of interesting. I think this is that's very professional. I think it's the defense attorney on the right, the prosecutor on the left.
All right. Boy, that was long. Here is Malik Henderson.
Well, there you have it. The baby drill saga. If that thing goes to trial and it's out there, I think we're in. I want to see that trial. That'll be ugly. Ooh, some of the exhibits on that are not going to be good. Not good. But it'd be an interesting case. There's no two ways about it. All right, thank you. We got range here at Law Talk with Mike. I do like the funny ones or whatever, but that one was just so interesting. I couldn't not do it. I could not do it. I still don't to this day. Somebody tell me. I got a pile of attorneys and judges and everything in here. Tell me in the comments why they're re-indicting. I don't understand it. There's a good reason for it, but they may want to like amend their charges, or they literally may be going through the process and getting information and just want to narrow the scope of the issues. I don't know. It seems like they've got him indicted right now. I don't see why they would nolly that and then re-indict, but there's a good reason for it. There's a good reason for it. Judge McBurney didn't seem surprised by it. A defense attorney kept trying to say that there's some grand conspiracy because they waited till the 11th hour to file, but that's to an attorney that's laughable because that's every day. That's just what happens. All right, thank you all for coming out. I know that was a long one. I know it was a little bit dry, but it was also super fascinating and interesting. And think about it now. Now you know who Baby Drill is. All right. I will see you all soon.